Hi, thanks, Dan. Thanks, everybody, for joining us today. I'm here to talk about the Stericycle decision from the National Labor Relations Board and how that is going to affect your employee handbook. So what is the National Labor Relations Act? That is the law that is affecting us all, affecting our employee handbook. So the National Labor Relations Act has been around since 1935, and it guarantees the right of private sector employees to organize and engage in collective bargaining and take collective action. So really, it protects the right of employees to talk to each other, to share complaints, to get together, to try and help each other, to try and talk about their working conditions and get together and form a complaint and go to the employer as a group. So the NLRA kind of protects that ability for employees, and it's based on the idea that employees there's an inherent imbalance in power between employees and employers, and employees inherently have less power, less bargaining power than the employer, and we need to kind of create an equal balance between employees and employers. And part of the way we do that is by letting the employees all organize together and come together as one unit, which brings them a little closer up to employers. So, but I'm not a union shop. Some of you hear NLRA and think that's for unions, that's for union shops. That doesn't have anything to do with me. So the NLRA still applies to you even if you are not a union shop. So like I said, it protects the right to organize into trade unions. Well, organizing into trade unions does not just mean that the AFL-CIO shows up at your workplace and starts passing out pamphlets. And engaging in collective bargaining does not just mean that your employees have hooked up with the AFL-CIO and now you have a union shop and the AFL-CIO negotiates your CBA. The right to organize into trade unions and collectively bargain includes the right of right down to an employee on Facebook saying, I'm getting paid X. What are you getting paid? I don't think this is fair. Like this post if we need to put a stop to this. And all of the employees getting together and forming a group, going to the employer and saying, get all of us to agree to your conditions, or none of us will agree to your conditions, and we'll hold a work stoppage if you don't negotiate this. Generally, if your employees are going to organize, they're going to affiliate with an existing union, but you can't intervene anywhere during this process from the first post on Facebook all the way to affiliating with an existing union or holding a work stoppage. You can't tell your employees things that aren't true about the union, or tell the employees that the union is going to take away benefits that you that they get with you, and kind of spread lies about the union. You can't intervene anywhere in this whole process of organizing and collectively bargaining. This is all the employees' rights, and you can't step in anywhere. So even if you're not a union shop, if your employees start coming together and saying this is unfair, you can't quash that at any point. So the NLRA still applies to you because you can't prevent two or more employees from saying this is unfair, let's do something about this. The NLRA says you can't silence discord with discipline. You can't stop two employees from putting up a poster publicly that says you don't give meal breaks. If it's true, if you don't, you can't stop two employees from putting up a poster in a public place. You can't intervene at any point during the process. So how does the law change? When we talk about new laws, excuse me, for the with the NLRB coming out with new laws, and all of a sudden things changed and we have to change our handbook, how does everything change? So the general counsel, you can kind of see here how the NLRB is set up. The general counsel is the prosecutor in the hearing taken before the ALJ, the administrative law judge, but then the general counsel must promote and endorse the decision by the board. So even if the board, even if the general counsel is prosecuting the employer and the board decides that there was not an unfair labor practice and sides with the employer, the general counsel has to promote and endorse that decision. The board doesn't have to agree with the ALJ, and the board frequently overturns its own precedents, which is why we are here. The board has released previous decisions that we have relied on in making our handbooks previously, and now they have overturned that, which is why we all need to change our handbooks. Excuse me. The board is the NLRB, the board is the agency that enforces the NLRA. So their decisions inform how the law is going to be enforced. It stays that way until a new decision is issued that says something different. We all like I said, we all based our handbook on the last decision they issued. Now they've issued a new decision. This means the NLRA is going to be enforced differently. So in order to prevent committing an unfair labor practice and having a charge brought against us, we have to change. And basically the decisions we have to follow, they're federally enforced. They come from the board. The board is federally empowered to enforce the law. What are the penalties? The penalties for violations are cease and desist orders. They can be back pay to an employee who was directly affected by the violation, but recently an April 2023 decision has paved the way for enhanced penalties for employers that have yet to be seen. So this may go beyond cease and desist orders at this point. The Boeing Company, this was the previous ruling that we were all basing our handbook on. This was when the NLRB was made up by Trump appointees, and when now the NLRB has shifted to Biden appointees, and it was just going to be a matter of time before employees started seeing some protection in the handbook. So the Stericycle decision started the same way as any claim, with employees making a charge of an unfair labor practice filed at their regional office. The regional office found cause to issue a complaint. The general counsel made the decision to prosecute the complaint, and the board made a decision. It followed the procedure exactly the way any unfair labor practice claim would be processed. So Stericycle just came through. It just happened to be one whose decisions had big results. So critical changes. So the NLRB was looking for anything that had a chilling effect on employees' right to engage in concerted effort for mutual aid. So anything that might potentially deter an employee from reporting harassment, anything that might potentially deter an employee from reporting a safety issue, anything that might allow an employee to complain about wages, anything that might allow employees to take a picture of unsafe working conditions. There's that imbalance of power between the employee and the employer, and that's what they're focusing on. For example, if you have a process, if there's an unlawful deduction on your paycheck, you have to go see Pam. If Pam doesn't help you, too bad, you're stuck with it. If that's your procedure, then that's something that they're looking at that has a chilling effect on your right to engage in concerted effort, because you think, well, Pam is the end of the line, and I'm stuck with this. You may have a legitimate business interest in having harassment complaints being handled by one person, but is that the most narrowly tailored way of making that happen? Or is telling employees, hey, you can report to HR or any member of management or supervisor, and then training those people to pass the report on to HR, is that still a way you can protect your business interests? So that's they're trying to reduce the chilling effect on the employee's right to engage in the concerted effort for mutual aid. Confidentiality, there's that chilling effect again. You have to keep the results of an investigation confidential. You have to keep your participation in the investigation confidential. Some of you have these rules. Do those rules chill employees' rights to get together and engage in concerted activity to seek mutual aid about a harassment problem at the company? You bet it does. Employees are not going to be able to fight back against a harassment problem at the company if they're not allowed to talk about it. So what is your legitimate business interest served by telling all employees to keep it confidential? Is it to keep more people from reporting harassment? Well, that's their Section 7, right? Concerted activity, more people reporting harassment. Is it to keep the public from finding out? If employees are allowed to seek mutual aid, they can talk about the harassment. They can find ways to get together and seek help for their problem. Is there a narrowly tailored way of containing this? Talking about allowing employees to talk about results of harassment investigation or participation in the investigation? Probably not. There's probably not a narrowly tailored way of containing this. Employees have to be allowed to talk about it. And that's going to have to change. Use of personal electronic devices. No more your cell phone has to be locked in the car or locked in your locker all shift. Many cell phones have cameras. They could be used to record safety issues, harassment, things that they could show to their coworkers and get their coworkers involved. Again, you have to have a legitimate business interest, and your rule has to be narrowly tailored. Do you have a legitimate business interest in not having your employees walking around on TikTok all day? Yes, of course. What is the narrowly tailored rule? Employees may have cell phones on their person during work hours, but may not call, text, look at the internet, or use social media during work time. What happens if you have an employee who isn't getting any work done because he's ambling through the workplace all day, taking pictures of the corners, saying it might be in unsafe work conditions? Ask me when it happens. I haven't heard that happen yet. So if that happens, if you have an employee who's taking pictures all day and not getting any work done, open a ticket and ask me. I haven't heard that happening yet. Conflict of interest. So that this actually covers a lot. So this is no more no outside employment rules unless they are narrowly tailored to meet a legitimate business interest, such as no working for a competitor. So no working for a competitor, but other than that, no outside employment rules are gone. No rules that employees must be courteous or civil in the workplace. No rules against insubordination. No rules against offensive language. You can still prohibit discriminatory or harassing language. But no insubordinate or offensive or discourteous language. Employees may need to be insubordinate or discourteous if there is a labor dispute. If employees want to come together for mutual aid and oppose an unfair labor practice, that might not be polite, but you need to narrowly tailor your rules and say no discriminatory or harassing language to protect your employees' unequal bargaining power. Social media, you have to let your employees identify themselves as an employee of your company. That's how they find other employees for mutual aid. You can't prohibit them from posting that they work for you. Again, you can't prohibit offensive or discourteous language on social media. Of course, no discrimination, harassments, illegal activity, threats. That's fine to ban that. No rule about take your complaints to us first. Before you post them on social media. Employees have the right to post complaints. An employee can insult a manager on social media as long as it's not illegal discrimination or harassment. So as long as they're not insulting them based on their protected class or it's not sexual harassment, your employee can insult a manager on social media. No non-disparagement. No rule against behavior that would tarnish the reputation of the employer, no rules like that. You should add something with your social media policy about that supervisors should not friend request or follower request their subordinate employees, but the other way around is okay, that subordinate employees can request their supervisors. But supervisors should not be requesting subordinate employees. Electronic communication. So employees need to get in touch with each other to organize. Sometimes they don't have each other's outside contact information. You have to let them call each other on the business phone. Limited personal use of employee email is as narrowly tailored as you're going to get, but you have to let them use work email to contact each other about concerted efforts for mutual aid. So you're going to have to let them use those methods to contact each other if they don't have each other's personal information. Camera and video use, as above, we talked about no cameras or no video recording rules. Even those of you who have policies in your handbooks that say no cameras or videos unless you are exercising your Section 7 rights, I would throw that rule right out. I would throw the whole thing out, even with the qualifier. It's still chilling. I think it's still chilling even with the qualifier on that. Throw it out. If there's an unsafe condition in a locker room or a bathroom or in any room in which an employee has a reasonable expectation of privacy, the person recording the recording should make sure the room is empty. You can prohibit taking videos or pictures where an employee has a reasonable expectation of privacy. Do not take videos of people using the toilet is a narrowly tailored rule, and that is okay. So I realize I've gone over here, but that is a quick summary of the Stericycle decision.